A tenant is thousands of dollars behind on rent, a landlord says he's run out of patience, and a judge is caught in the middle trying to decide whether one final chance is deserved. What makes this case so dramatic is that both sides tell very different stories. The tenant insists a new job and a delayed tax refund will solve everything, while the landlord argues he's heard these promises before. As the hearing unfolds, contradictions begin to emerge, trust becomes a major issue, and the possibility of eviction hangs over every word. Will the judge order the tenant out immediately, or will one last opportunity change everything? Stay tuned because this case takes several unexpected turns.
Substantial. She owed $5,200 through April. Rent was $800 a month. And then, through March. We added April's rent, which made it $6,000 plus court costs. $6,424 is what it would have cost through April. So she indicated that Keystone was going to help pay part of it. She had a new job at Ox Paperboard. So we continued the matter until March 31st. We made the same finding we did on March 31st, that the amount of rent was $6,000. There was $175 of late fees, and Keystone was going to pay a portion of it. That did not happen. The rent was not paid. Plaintiff requested a writ of eviction, and that is sitting here. It was filed April 13th, so now it's April 28th. 15 more days have passed because I was on vacation. You wrote me a long letter that I had a lot of trouble reading, but the bottom line is you haven't paid the rent and they still want you to move, and they've asked me to file a writ of eviction. Ms. Brandow, anything you wish to add? Were you able to read her letter?
I did read what I could understand of it, Your Honor. I have spoken to my client as well, and just here to see, how we can proceed and how we can help Miss Wanda with her concerns.
All right. Well, she keeps saying he won't talk to me, but he doesn't have to talk to her. He was doing this through you. I would put the three of you in a breakout room, but somebody's in the breakout room. So is your client willing to work with Miss Lewis?
Only to a certain extent, Your Honor. This is the arrearages here, like you said, are substantial. I don't see how she is going to be able to get caught up anytime soon, especially with the additional rent being added. Additionally, there are some electric bills that are unpaid that my client is having to deal with.
No, those are paid.
At this point, the judge is focusing on the central issue of the case, unpaid rent. Legally, the landlord is not obligated to continue negotiating if the tenant has fallen significantly behind and previous payment arrangements have failed. Notice how the judge repeatedly redirects the conversation back to the arrears instead of side issues. The tenant believes communication problems contributed to the situation, but from the court's perspective, the key question is simple: has the rent been paid or not? The emotional tension is obvious here. The tenant is trying to convince everyone that better financial circumstances are right around the corner, while the landlord's attorney is emphasizing the growing financial losses. What would you do if you were the landlord in this situation? Would you give another chance or move forward with eviction?
An amendment, and my taxes at that time was $10,542. So I had no problem paying everything up until I started working. But however, I have no problem with at least paying Mr. Hatfield $1,000 a week. And I still told him when taxes when they do come, I would also pay him extra months of rent when it comes. But unfortunately, I had to go to the IRS to identify and have them amended as well, because the person that did them really screws them up. So I had to go to H&R Block and have H&R Block amend them. And they are I have a few more weeks before they come. But I have no problem with at least paying Mr. Hatfield $1,000 a week and catch it up, and after that, pay him.
Well, 1,000 a week is a substantial payment.
Well,
They don't have to, they have 56 days to ask for the writ of eviction, and then they have an additional 56 days before they serve it. So that gives them quite a bit of wiggle room. They have requested a writ of eviction, but I have not signed it. Ms. Brandow, what's your thoughts after having heard what Ms. Lewis said?
Your Honor, I would have to check with my client as far as whether he is willing to rely on Ms. Wanda's representation on what she can pay per week. I would have to check with him on that because I know that he has tried to work with her in the past and has not been given the money that Ms. Wanda has indicated that.
Are you in the house now, Ms. Lewis?
Yes, Judge.
Well, it looked like it was a mess. It looked like it was all in terrible disarray.
My house?
Yes.
Oh, no, this is the porch. There's nothing dirty about the porch. It's just kids' toys. I keep this house, anytime anybody ever
All right,
comes
well,
here.
when you were in the garage or something is maybe
No,
when all
this
the
is the
crash and
porch.
banging's going on.
I don't have a garage. This is the porch. And
Right.
there's nothing, it is nowhere near dirty,
right.
a mess at all.
Well,
I don't
to
live
some
in dirt.
extent, when we have the hearing, we had 2 hearings,
Yes.
and then I made a ruling, and then you wanted to talk to him, and he's like, I don't want to talk to her anymore. I had 2 court hearings, pay the money or move. So you wrote this long letter, and I set this hearing, and Ms. Brandow did talk to Mr. Hatfield, but you're gonna be more than $7,000 behind on your rent. And
Yes, and that would take me
we had in
about.
May's rent. You said Keystone was gonna pay some. What happened to that?
Well, Keystone sent a letter stating that what they were going to pay. They didn't tell me that I had to pay the rest before, so I had called like 211 to help out, but they nowhere had any funding. So after I couldn't come up with the other amount that was on the letter, then Keystone said that once I start paying on it, then they can help with and it was $1,000. But once
At this stage of the hearing, the judge shifts from legal questioning into something far more personal and emotional. Miss Hope explains she needs to work, care for her child, and survive day to day, even if it means suffering physically. This is where the court acknowledges a harsh reality. There is no easy solution when disability, income limits, and housing insecurity all collide. Legally, the judge does not issue an immediate eviction judgment. Instead, he adjourns the case and schedules 2 future hearings for May 5th and May 12th. This is very important. It means the court is pausing enforcement, not ending the case. The $5,352 owed remains unresolved, but the judge clearly signaled flexibility while outside agencies, including state departments and SOS representatives, attempt to find funding solutions. Emotionally, the judge even reflects on personal wisdom, make a way out of no way, showing rare courtroom empathy. But beneath that compassion lies a warning. If no solution is found, legal consequences could still follow. White right pointing backhand index, do you think giving more time is justice, or just delaying the inevitable?
You file the action, then you get in trouble if you accept partial payment. But I will allow the defendant to make any payment without precluding the plaintiff's ability to proceed. This isn't a termination of tenancy, it's a non-payment of rent case. But perhaps it will be safest to see whether she puts up or
is
not.
there any way you, I, and Mr. Hatfield can have a meeting?
Can have what?
A meeting. I'm speaking to the lawyer.
I will
Well, I don't
certainly,
think he wants to have a meeting with you. I think he wants to do this through his attorney, but that's up to him.
through his attorney, or he's also requested that, in the past, he's also requested that communication go written only. And the reason for that was that they were having communication problems when everything was being done verbally. And that was why he did not respond.
Well, and again, that's not true.
I do have text messages to that effect in writing that my client has sent me,
Well, that's
that he
his
sent to you.
contention.
Yes, we have the same messages.
Oh, boy. I'm gonna continue this for 10 days. Continue request for stay of writ to May 15th, 2023 at 1:15. To see whether he's agreeable to continue this. If not, they're entitled to the writ.
Yeah.
You want him to work out some deal with you, but he doesn't have to. He
I
can say,
understand.
I've had such a bad history with this client, I don't want to get another $800 and another $800 behind. I want to just get her out of there and get another tenant in there. So you could show some good faith. We've been going at this for months, and so far no money has been tendered for payment. So
No,
you're
because
saying,
it was hard to find a job, but I am employed now.
all right, well, you
As I
told me
usually
back,
always am.
you told me a month ago, when did you start at Ox?
Monday.
Last Monday?
No, I did orientation and all that, which we get paid for, but my actual start date is going to be Monday. I've been in there back and forth this week doing orientation that we get paid for, et cetera, but my
Well,
actual.
you told me that back on March 24th.
No, on March 24th, I never told you Ox because I was supposed to go to.
No, yes, you did. I wrote it down and we can watch it. You told me you were the same thing. You were going through orientation. You were going to start on Monday. That's what you told me on March
At Ox
24th.
Paper Mill. I just did a.
Yeah, you had temporary at Pfizer and you were going to start at Ox.
Oh, yes, the one in White Pigeon, but they did not call me back, but the one in Constantine, I've done my orientation and drug testing after my surgery, and that I definitely start there Monday.
Well, I have some reservations as well, Miss Brandow. If this isn't going to work, Miss Lewis, I'm inclined to enter the writ of eviction on the 15th of March.
I don't have a problem with paying them $1,000 a week.
Well, they may not want $1,000 a week. They want $7,000. They want it all at once. They don't want to wait 8 weeks or 10 weeks to get paid. They don't trust you. And you told me in March that you started on Monday at Ox Paperboard, and here we are 32 days
Yes, the
later,
one in
and you
White
still
Pigeon.
haven't.
Yes, the one in White Pigeon did tell me that I would have a position out there.
You told me you had gone through orientation and you were going to start on Monday, which is the exact same thing you just told me just now.
I don't. At Ox Paper Mill?
That's what I wrote. All right.
No.
All right. I guess it's time to put up or prepare to move out. She can discuss this with her client, but we're already lopping over into the next month. So I'm costing him another $800. What she wanted me to do was execute the writ of eviction immediately today and have the sheriff come put you out tomorrow. You have to pay the rent or move, and you want a payment plan, but he hasn't agreed to give you one. And you wrote a treatise of a letter, but that's really what it boils down to. You either need to pay the rent or move. Keystone was going to pay. You were going to get your tax return. You were going to get a job at Ox. The check's in the mail. I only had 2 beers. You know, he doesn't believe your representations because they haven't been borne out in the past.
I've never said check in the mail if there's not a check.
In the end, the judge stops short of issuing an immediate eviction but makes it clear that the landlord is legally entitled to pursue one. Instead, the court grants a brief continuance, giving the tenant one final opportunity to demonstrate good faith and show real progress toward resolving the debt. Throughout the hearing, the judge repeatedly pointed to missed deadlines, unfulfilled promises, and the steadily increasing rent balance. Meanwhile, the tenant argued that a new job, future income, and delayed tax funds could finally turn things around. The broader lesson from this case is that courts often consider both financial hardship and credibility. Promises alone rarely carry the day, documentation and action matter most. Now we want to hear from you. Do you think the judge made the right decision by granting additional time, or should the eviction have been approved immediately? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.